Hello, everyone, and welcome to On Civil Law. For today's case, we have a decision from the Court of Appeals for the Seventh Circuit out of Illinois. This is a case of Ura Elson versus the County of Kane. Now, I think many of us are familiar with those parents who are a little bit too serious about children's sporting events. They tend to yell and berate their umps and just be basically, way too possessive and way too serious about the whole thing rather than letting the kids enjoy it. Well, we have an incident much like that, except the parent in question here was an off-duty sheriff's deputy. So all kinds of interesting things happened. So we're going to read this case and discuss what happened in this case of a law enforcement who let not only the sporting event, but his children's game go way to his head. Let's get started with this. Ura Elson and his friends were playing basketball at a park in DuPage County while Brian Demeter, an off-duty sheriff's deputy for neighboring Kane County, watched his child's soccer game on an adjacent field. When Elson and his friends started heckling one another with salty language, Demeter confronted them and demanded they stop using expletives. So here we got presumably teenagers playing basketball on one court in this place while his kids' soccer game was happening immediately adjacent. And so these teenagers who were playing basketball in this space started using salty language at each other, as harassing each other as teenagers do. Now, this person was so offended by these words that were coming from lest his darling child here, they went up and said, "Please stop using." And, if he had just said, "Please stop," that would have been fine. But of course, it didn't quite end there. Demeter? I think Demeter is better than Demeter? I mean, I think you could pronounce it either way. Demeter or Demeter? Demeter or Demeter. I think you could pronounce it either way. I don't know how he pronounces it, but that strikes me as something you could pronounce either way. You think it's Demeter, though? Flashing both his badge and gun from under his plain clothes, Demeter also warned the group to watch who you're messing with. When the boys refused to clean up their language, which, having been flashed a gun at me, I'd clean up my language, but these boys chose not to, so good for them for sticking to the man, I guess. Demeter grabbed Elson by the neck, threw him to the ground, and climbed on top of him. How very measured. At some point during the struggle, Demeter tried to pull Elson's arm behind his back as though attempting to arrest him. Bystanders separated Demeter and Elson, but not before Demeter could rip Elson's shirt and attempt to keep a hold of him. This is just not going great. The sheriff's deputy is kind of overreacting to this, I think. I don't think it's attempted rape, no. It's attempted something, but I don't think that's, no, it's not attempted rape. It's not the intent of the act. I don't think that flows. I mean, this kind of action could be, but you have to, when you look at intent, or apologize, when you look at attempt, you actually have to find intent for the underlying act. So like one of the differences between attempted murder and murder is that for attempted murder, you actually have to have the subjective intent to commit the murder. Whereas for murder, you don't necessarily have to have intent to commit murders. Lower mens res can do. So there's a differentiation there. So, yeah. After the fight broke up, Demeter called 911 from his personal cell phone, identifying himself as a police officer in need of assistance. Great. When Elson's father, who Elson had called for help, arrived at the park, Demeter explained the incident by saying something along the lines of, "I just lost it, or I snapped." He then told Elson's father that he was a police officer attempting to take Elson into custody for disorderly conduct and he intended to turn Elson over to the Aurora Police Department. This is just going really well. Why are you manhandling my son? I lost it. Okay, well, that's not great. Okay. Elston, the victim, was never charged with any offense, but Demeter, the cop, pled guilty to violating Aurora's ordinance against battery. Elston then sued Demeter under 1983 and Illinois state law, winning default judgment and an award of $110,000 in compensation damages. So default judgment means that the cop didn't show up to the lawsuit. He didn't even show up at all. That's what a default is. So he sued for violation of rights, and the cop never bothered to show up to provide a defense. Like, he had a pretty colorable qualified immunity claim, because we know how far qualified immunity can go, right? So he probably had a colorable qualified immunity claim in there somewhere, but he didn't show up. Why? One can only begin to speculate. And so this kid got $110,000 in default because he never showed up. Okay. Alston also sued Kane County under Illinois Tort Immunity Act, which provides that a local public entity is empowered and directed to pay any tort judgment or settlement for compensation damages for which it or an employee, while acting in the scope of the employment, is liable. So, long story short, because this is a police officer employed by the state may be liable for this. Now, he wouldn't be liable under 1983. That much is very clear. 1983 has made it very, very clear. There's no like respondeat superior liability, no agent actor responsibility. So, if the cop did a bad thing under 1983, the police officer, the police force is not necessarily on the hook unless you can show violations there. Neither is the government on the hook. So that's very clear. But under the Illinois Tort Act, as a matter of state law, here it says, yes, you can hold the police force responsible if he did it in the course of his official action. So that's the difference between 1983 and the Illinois law. And then the issue becomes, was this part of his official action or not? So we have to get into that issue. The county moved for summary judgment. The district court granted the motion, and Alston appeals that determination. But the district court got it right. As a matter of law, Demeter was acting as a private citizen, not within the scope of his duties as sheriff deputy when he entered Alston. And we've seen this kind of thing before. We saw this in a prior case we covered on uncivil law, where a police officer who was off the clock but still carrying their gun went to a person's home to collect a personal debt. And I forget exactly what happened after that, but that court also ruled that's not official action. Because even though they have their gun and badge, it still isn't official action. So I guess it's the same analysis here. It's not closely connected enough. So I don't know if I agree with that decision here, but that's what the law seems to say. Okay. Under Illinois law, there are 3 necessary criteria for an employee action to be within the scope of employment. First, the relevant conduct must be of a kind the employee was employed to perform. Second, the conduct must have occurred substantially within the time and space limits authorized by the employment. And third, the conduct must have been motivated, at least in part, by a purpose to serve the employer. The parties dispute whether Demeter's actions satisfy the first criterion, that is, whether the conduct was of a kind Demeter would perform as a sheriff's deputy. We're willing to assume for the sake of argument it was. But even so, Alston cannot succeed because he's not met his burden on the second or third criteria. The interaction as described leads to only one conclusion, that Demeter was not acting substantially within time and space limitations authorized by his employment. Demeter was not on duty during his altercation with Alston. He was spending his day off with his family, who must be super thrilled, watching his child's soccer game. Demeter was not in uniform when he attacked Alston. He was dressed in a t-shirt and shorts. And the assault took place in DuPage County, while Demeter is authorized as a sheriff deputy only in Kane County. Thus, Demeter was neither on the clock nor within his jurisdiction when he attacked Alston. That, combined with the facts that Demeter was in casual dress and on a family outing, dictates a finding against Alston on this element. So I suppose that's fair as far as the law goes, right? He's not in the same county he's employed in. He's a sheriff's deputy, so sheriffs only work within their jurisdiction. They typically don't work across jurisdiction. He's in casual clothes, and this is not in any sense like something his employer wants him to do. So it's not within the time and space issues of his employment. So that makes sense. Now, he only had the badge because he's an employee, and presumably this is his department issued gun, which he only has because he's an employee, but still he's acting as a private citizen in this instance. Well, I'm not sure that totally makes sense to my mind, but it's what the law seems to support, so okay. Likewise, no reasonable jury could find for Alston on the third criteria, that Demeter's contact was caused, at least in part, by a purpose to serve the sheriff's office. We've characterized the inquiry as whether the employee's motive, or at least a motive in committing the tort, was to serve his employer. While a mixed motive may be enough to create liability, an employee who acts purely in his own personal interest cannot create liability for his employer. Demeter had no authority to make an arrest or take other actions to keep the peace during the incident. As we noted, the office's policy prohibits off-duty deputies from making arrests or performing other enforcement actions outside their jurisdictional limits of Kane County. In order to obtain relief, a plaintiff must show that conduct, despite being nominally prohibited by employer, was nonetheless undertaken to serve the employer's interests. For example, in a prior case, this court held that an off-duty officer acted within the scope of employment when he negligently stored his unlocked firearm in an unlocked cabinet at home. Super. The gun was used by the officer's son to shoot and kill a victim. Yeah. The court held that the officer serving his employer's interests, at least in part, because by storing his gun as he did, because he was a Chicago police officer on call 24 hours a day in the city of Chicago, so he desired to have the gun accessible in the event of an emergency. And that was true notwithstanding the fact that the police department's policy prohibited storing official firearms in this manner. But not every action motivated by the notions of the public interest will count as furthering a government employer's purpose. Thus, no reasonable jury could conclude that Demeter's actions were motivated, even in part, by an intent to serve his employer's interests. Instead, on his off day with his family, Demeter acted out of personal animus to accost, threaten, and physically assault a teenager for using foul language within earshot of spectators and players at a children's soccer game. The fact that Demeter used his badge, gun, and training in an unauthorized manner in pursuit of the purely personal goal does not bring his conduct within the scope of the employment. So that is the end of the case of Ura Elston versus County of Kane. In this case, we learned that a police officer, a sheriff, while off duty, was attending his kid's soccer game, and in an adjacent basketball court, presumably teenagers were engaged in basketball and were using foul words in an attempt to taunt each other. Now, he could have gone over and simply said, please stop, my kid is playing nearby, I don't want them to hear it. I'm sure that would have been fine, but what he did instead was expose his badge and gun, then crawl on top of the kid and try to arrest him or something. And the Court of Appeals here is rightly pointing out that he can be sued for this violation because it was not because he acted improperly. But his employer can't be sued because he can't be sued under 1983 because it doesn't allow for vicarious liability, and he can't be sued under the Illinois state law because this police officer was not acting in furtherance of his employer's actions or in his employer's goals. His employer didn't want these things, and it was against policy. So that makes sense as a matter of law, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.